Hello, hello. Are we live? It appears we are live. Do we have good sound? Good evening, Sean S. I hope you are well. We got 5 people in the live stream already. That's not half bad. That's a good start. We got 1 like. Thank you for the like. The like is how people see us, so I appreciate you. We're just going to let things run until I get my first question. Definitely going to let things run until I get my first question. You're going to be waiting a long time if you're waiting for the legend, because I'm just a guy on the internet. But it's very kind of you, Anish. I hope you're well. Do you have a question? Shoot away. Let's answer some questions. Okay, you've got a hearing coming up. Oh, and you're going to be representing yourself. I'm sorry to hear that. Never ideal. If your hearing is coming up, generally, I would not expect there to be a motion to dismiss. I don't know the specific procedures for CMC, but I would expect you might. It's possible you might face something like a summary judgment motion, but I don't think that it will. I think you're going to be all right. I suspect. It sounds like the CMC is an agency. And generally, if an agency gives you a hearing in most of the country, you're probably going to get that hearing. Tez Zinro says, I've got a drink and dinner, and I'm ready to listen to Vince talk law. Very kind of you. I hope. What are you drinking tonight? What are you drinking? Pamaroon says, questions. How can an attorney beat the stigma of being a billing hungry liar? The negative stigma of attorneys is real. Pamaroon, I don't know why I'd want to beat that stigma. I mean, I generally don't work on an hourly basis unless I'm sitting as an arbitrator deciding a case. But that being said, I have no interest in people calling me and thinking that I'm going to work for free, right? Generally at our firm, we're working for primarily a contingency, primarily a percentage of the case in terms of what we win for the person. But I don't think it's negative to say, oh, attorneys are in it for the money. Yeah, that is accurate, right? Like nobody would do this job for free. This job is not the hardest job in the world, but it's certainly not the easiest or the most fun. It's fighting about hate crimes every day. So, I mean, the compensation matters because it gets people helped. B Me says, my New York State human rights law, New York City human rights law charges survived a motion to dismiss. Congratulations. That's tremendously good news. Tez Inro is drinking the original Sin McIntosh cider. I love that for you. That's wonderful. Pantera Rage asks, first off, great username. Exhausting my 90-day right to sue letter. Can it be extended? Realistically, no. You should think of your right to sue letter as something that cannot be extended. So if you're about to run out and you want to protect that right to sue letter statute of limitations, you should get it filed even if you don't have counsel yet. ENY, excuse me, says 1, does the New York City Commission on Human Rights ask the other side do they wish to mediate after finding probable cause? No, but you might find in a fact-finding conference, or not you might find in the preliminary hearing conferences when they're setting up the scheduling and everything that they'll talk settlement. Anish, if you are representing yourself, you are allowed to speak. Yes. Anish asked, am I allowed to speak at the case management conference? If you're a pro se, you are certainly allowed to speak. Hush Money says, what is the difference between a motion to dismiss and a motion for summary judgment? Excuse me, Hush Money. We have a couple of videos on the channel. We actually have summary judgment and I believe also motion to dismiss playlists, but we certainly have summary judgment playlists. And the difference between the two is discussed exhaustively in those videos. I think it's going to be more valuable to you to watch those videos and hear my answer here. So I would suggest you do that. B.Me says, do 1981 motion to dismiss survivals typically scare employers to settle? No, 1981 is not a particularly scary claim. It's good. You certainly want it in your case. You want to include it if it fits. But it's really in many cases a utility claim that is good and valuable, but not a terror-inducing claim. ENY says, why does the New York City Commission on Human Rights ask for a demand number if they can come up with their own? So the New York City Commission on Human Rights can't set your demand. I think you might be thinking of the National Labor Relations Board. So New York State Commission on Human Rights they can tell you what they think you should settle for, but they can't tell you what to settle for. So they need to know what number you're okay with. Anish says, my old attorney sucked. He accepted an offer without my consent. Thankfully, I did not accept the agreement. Well done, Anish. I'm glad to hear that you are perfecting your rights. Kareem Sawyer says, how can we amend our charge to add additional charges? So if you're pending in the EEOC and you're looking to amend that, you can just file an amended charge with the EEOC. You may want to contact your investigator first and ask if you can have leave to file the amended charge. But realistically speaking, even if they don't accept your amended charge, they're just going to accept it as a new charge. You're going to have two charges running, so it'll be included anyways. Anish says, Vince is the best online attorney. There's some pretty good ones. I don't know if I'm the best, but thank you. Very kind of you. Excuse me. NYC Damages says, when I use FOIL, the Freedom of Information Law, to prove that an agency is corrupt in an employment discrimination case, does the agency itself handle this? Asking because they say they don't have the information that they already used, meaning they aren't following FOIL. Yeah, I mean, at some point, the agency itself is required to be engaged in finding the documents you're asking for freedom of information. So generally speaking, a lot of agencies are going to have specific teams that are meant to comply with those laws. Teh Zinro says, the employer's response said my performance suddenly dropped off, also known as after my glowing performance review. Never told me this, though. What's some good evidence to look for to counter their claim? So, I mean, ideally, if you could get evidence, performance reviews or testimony from someone who was charged with reviewing your performance who would counteract that, that would be ideal. Mr. D says, what's a reasonable amount of time to wait for a settlement check when everything is in-house, as in the defense is an employee of the corporation that is settling? He is a major flake, sadly. Generally 30 days, 28 days would be a good amount of time to get your settlement check, I would say. All right. Aquarius 182 says, in the event I get a new job and leave my old job voluntarily, could I still sue my former employer for bullying, harassment, retaliation, and a failure to accommodate? So, excuse me, leaving the job voluntarily does not mean you can't sue. It might mean your case might not be worth as much because the damage has stopped growing, right? You've mitigated, you found another job. So you could still sue for all viable claims. Now, generally speaking, bullying and general harassment are not claims in most jurisdictions, but of course, retaliation claims and failure to accommodate claims are. So you could certainly bring all the viable claims wherever you are. The valuation just might change if you exit and find alternate employment. Pamaroon says, the top 5 red flags to know when an attorney is working with the other side. I've got videos on this. I mean, it is very rare that the attorneys are going to be on the take from the other side. It's just not generally going to be worth your license to do that. And I understand, like, there's suspicions like, oh, I don't think it's a formalized arrangement. Like, I don't think he's going to get caught. He doesn't think he's going to get caught, so he's doing it. I will say, Pamaroon, I think that's very rare. Anish says, can I pay for all your expenses to represent me in California? LOL. We are incredibly expensive to handle cases. So I mean, you have a lot of really good local options in California. I would recommend that you utilize them. If you want to call our intake team, certainly we do handle cases in California. But I would recommend, generally speaking, that you speak with the local options in California, the local attorneys in California. There are many really good options. Aquarius 182 says, could you recommend employment attorneys based on Long Island? I'm not supposed to recommend attorneys because our insurance company says that I can't. So I can't recommend anyone to you. But I can tell you that if I had family members in Long Island who needed employment attorneys, I would probably slip them Weineck and Famighetti's cards, specifically Matthew Weineck. But that's not a recommendation, mind you. I can't recommend him. It's just that I would send my family to him. ENY says, how does the New York City Commission on Human Rights handle a new piece of expert medical evidence after finding probable cause? They would probably let you bring that in. I don't think that's going to be an issue as long as the other side has significant time to review it before the hearing. Excuse me. Kareem Sawyer says, in your position statement rebuttal, which is it? Position statement or the rebuttal? Can you use negative notations on employee file notes to prove retaliation? Sure. Yeah, if you think that you engaged in protected activity and then you have negative evaluations in your employee file, that could certainly be a sign of retaliation. Ted Zinro says, I do have copies of those great performance reviews. I think they're trying to say the change in performance was so recent that the review is now inaccurate. Well, that's a difficult argument for them. I mean, that's not the best narrative for them. So it sounds like you're in a good place with that one. I would say, at least. Sounds generally positive. All right. One moment, please. I really missed my mute button on my old microphone. Let's see. Marcus Hampton says, if I went to mediation and didn't agree with the terms, will the EEOC send me the right to sue letter? Eventually, yes. I mean, there's a good chance they're going to do some stuff in the meantime, like get you a position statement, give you the opportunity to write a rebuttal, stuff like that. But generally speaking, yeah, you're going to get that right to sue letter eventually. And that's what the EEOC does in the massive majority of their cases. They issue a right to sue letter. If they can't get the case settled, they certainly get you some free discovery along the way, but it's, that's often the result on an EEOC case if it's not being ushered into settlement. NYC Damages says, regarding FOIL, they have a records office, but this time they did not use the records officer. They signed the FOIL letter themselves as agency, not a name or title. Ooh, that's very questionable. That's a bit, as the kids would say, sus. That's sus. Very suspect. I don't trust that at all. I would, you might want to push back on that. You might want to follow the process to dispute a FOIL response. Sean S. says, good evening, Vince. An organization is being sued for racial discrimination. There may be another suit in the near future for them. Is it best to pile on the attack, to sue, or wait? Not too long, though. So, Sean, it's always best if you can pack punches in bunches. If I learned anything from working in bars, the people who came at you with punches and bunches were the problems, and so too are employers going to find that when they have multiple cases that corroborate each other going forward at the same time. Anish, I appreciate that you want to talk about hiring me, but I got to tell you, that's not something I do in a live stream. That's something you would do dealing with my intake department. I am here to answer free questions, not get money. But I really appreciate you. I'm not trying to be like a jerk about this. It's just not what I'm here to do. And I have built an apparatus to deal with that. And they are at your disposal 24/7. They are ready at my call center in King of Prussia, PA to field your call and help you if that's something you want. It's not that I don't want to help you. It's just that I don't want to help you right now because right now I am answering questions for free. YouTube user Bambino Dadon says, what can trigger a CEO or president, etc., to be sued personally for discrimination retaliation? I mean, if you're asking me, in my cases, what can trigger it? It would be if I felt it conveyed an advantage to my client in their case by like driving a wedge between the employer and the CEO, or if the company had imperiled assets in some way. Like I wasn't sure that I'd be able to collect from the company, but that CEO is well-heeled enough, affluent enough that I thought I could collect from them. It's really, if there's a reason that it's good for my client, that's what triggers that. And for me, it also has to be legally viable. Like you need to have the claims in place to make it worthwhile. Trey Morris asks, are arbitrators required to provide a reason for a decision? So arbitrators are certainly required to provide a well-reasoned decision in the organization that I arbitrate through, which is the American Arbitration Association, which handles, I think, like 70% of all the employment arbitrations in the nation, if not more. I don't quote me on that. I don't really know. But yeah, we're required to give a well-reasoned decision. Now, one of the reasons why an arbitrator always wants to give a well-reasoned decision is because really the only way to overturn an arbitrator is to argue to a judge somewhere. Now, this is in New York. I'm giving you a New York standard that may or may not be true where you are, so just be aware of that. You go to a judge and you say, hey, that arbitrator's decision was arbitrary and capricious. And generally speaking, if you're trying to get me overturned and I wrote a well-reasoned opinion, you might be able to get a judge to say, well, I don't agree with the opinion, but you probably will not get a judge to say that it was arbitrary because, of course, it's well-reasoned, right? Like it's not me picking out of a hat. It's me saying, hey, this is why I decided this, which automatically means it's not arbitrary, right? So it would be very counterproductive for an arbitrator to issue a decision that was not inclusive of some kind of well-reasoned argument, because then it would be ripe to be turned over, at least within New York, and I think in most of the country. Pamaroon says, why do attorneys share office spaces, and is that something folks should be concerned with? No, I don't think it's something at all. So I have almost always in my career shared office spaces. The biggest footprint our firm had in New York City, we had like half a floor in a historical building in Manhattan. And even then we were sharing the rest of that floor with other law firms, really great law firms who did other things. Right. So really this tremendous, first wave female attorney who was this amazing, personal injury attorney, med mal attorney. She was fantastic. It was great to know her. There was some matrimonial firms, there was a gentleman, very charming gentleman who litigated art theft and art fraud. And it's nice. It's nice to have neighbors who are not competing with you, but do understand a little bit about what you do. And also attorneys, I mean, it makes sense to share some level of expenses. You're going to have your own staff for your own firm, but that's not the person probably who's going to like get coffee for clients when they come in and stuff like that. Like you can share that person, which is, I mean, I'm not knocking that job, but it's not a high level. You're getting coffee, right? You're getting coffee. You're taking people to the conference room. You're signing them in. It's fairly simple. So you could have that person shared between like 30 firms, 5 firms, whatever. And it works perfectly fine. And everybody saves a bunch of money. Everybody's happy. Also, when firms like pool their money, there's a lot of firms who need like really good security. And I think you can probably guess that like really good security is really expensive because I'll be frank, like my firm has used its security repeatedly. Like there are people who come looking for me. And the security that we've had in various buildings has been utilized. Like those human beings have acted as security. Like they have in fact secured the building to our benefit. So like that's a shared expense. Like you can get much better security if you have 5 firms with 5 very different but very good reasons for having top-notch security. You can have the best of the best, or at least the best of the rest. Like it's not like we have Blackwater security, ethical considerations aside, but there's a lot of shared expenses. It doesn't bother me at all. The office I have in Manhattan right now is in a 2-floor suite with many other law firms. It doesn't bother me. It's just not really, New York's not really like it used to be anymore, right? Like I negotiated an office lease and they just said, hey, we'll give you a quarter of a year free, right? Like that's on a 1-year lease. That's how desperate commercial overtenants are at this point in New York. Case says, will the employer be able to see and or respond to the rebuttal? Generally, employers do see the rebuttal. Yes. Not always, but generally, yes. Bambino Dadon says, is there any specific that makes them personally liable? I think you're asking me. Yeah, generally speaking, they're going to have involvement. They're going to have to have been engaged as the bad actor to have personal liability in most. Questions are. What do we have here? Pam Maroon says, please place your YouTube plaque on the wall or elevate it, as keeping it on the floor is bad juju. I generally agree with you that I should do that. I've been trying to decide if I want to take it to the office in New York or keep it here, but I think it would go right there. I think I should put it right there. I'm also really bad at pointing to things in the camera. Horrible at it. But yeah, I'll get it. I'll get it hung. I'm just a little. Like I'm trying to get this office cleaned up after moving out of New York, and now. So I just finished moving out of New York, and now it looks like I have to move back, and like I have to get a place in New York again, in September, I think, which not what I wanted to do. I would need to know more. So I don't even know what your cause of action is, but it sounds like you're saying, hey, I've got the elements of my cause of action. So you have a case, but you also misbehaved. And one of the issues you could be facing here is that the way you misbehaved might provide a really good argument as to why bad things happen to you. And I don't know in the scheme of things if the misbehavior you're speaking to would be sufficient to, make your viable claim unwinnable or less likely to win. So the answer is devil's in the details. It's going to come down to specifics and judgment. Big Skeens says, hold on. Okay. Got it. Sorry. Something just happened. Excuse me. Big Skeens S says, to the offer is my job back, seniority back, no retroactive pay, and they want me to sign an NDA and go back to the same position under the same people who lied in the first place. What are my options? Your options are to take the deal, decline the deal, or counteroffer. Those are your options. Cat Zap says, I have an age and gender complaint filed. Well, actually, I don't know if you have a sexual harassment complaint or a gender complaint. You said I have an age and sex complaint. It could be either one. Filed with the EEOC as a breach of as well as a breach of contract and fraud related to those claims. Is it possible for all of these matters to be handled by one attorney? Yes, it absolutely is. Be forewarned that you will need to sell, like you will need to really pitch the fraud and breach of contract claim, because most people who have legitimate discrimination claims but also want to bring breach of contract or fraud claims, 9 times out of 10, maybe 99 times out of 100, those additional, the fraud claim and the breach of contract claim are not viable. I'm not saying yours aren't. I'm sure they are. I'm just saying when the attorneys hear that pitch, they're going to say, well, no, I don't want those additional claims. And you're just going to have to really explain why those claims are viable. And, I'm sure somebody will take it. All right. Whoa, jumping ahead. Mario Pont says, disability discrimination claim. Would I be able to claim disability caused misconduct? I mean, it would depend on your disability. I don't know what your disability is. But also, like, what's the misconduct? Like, if you're suffering from Tourette's, you're living with Tourette's, and the conduct is an outburst, then yeah, I think that's a pretty good argument. If you're suffering from, I don't know, a migraine disability, and your misconduct is, you threaten to murder someone, probably no, right? So, I mean, it's going to be very, very detail driven. N64 Glenn Plant, great username, says, Vince, can I have my weekly chicken check and status updates, please? You sure can. So, the war with the foxes carries on. They have been wily and incessant, and there are some teenage foxes acting the fool, and I have hired professionals to deal with them. I have lost, 6 chickens in 3 months, and that is just unacceptable. My little chickie babies, I can't have it. So we brought in professionals, and we're dealing. We're actively at war with the family fox, and it is ugly and unfortunate. And I love foxes, and I hate having foxes trapped, but I hate foxes killing my chickens for fun and then not eating them even more. YouTube user David Settle says, was discriminated against after 23 years, excuse me, and terminated by HR. And HR corporate stepped in and said he is a 23-year employee. I have an email where they were contradicting each other. Okay. I have a copy of company policy where HR skipped a step in the firing process. Discrimination. Okay. I mean, listen, that all might be useful in your discrimination claim. Generally, the company skipping a step in a termination process is not that meaningful, but it certainly could be in context. Big Skeen says, hello, I am a unionized employee. That's amazing. Who is wrongfully terminated. I filed a grievance of wrongful termination and harassment discrimination by management, and the company recently offered me my position back. In my grievance, I outlined strong evidence of harassment and discrimination, retaliation. The company is also aware I have evidence. I've only been terminated about 4 months, but I just don't feel like after. Oh, okay. So he can't post anymore. So Big Skeen, I'll read the rest once you can post it. David Settle says, I already answered that. Bambino Danon says, if I agree to mediation, can I pick the mediator? You will be able to participate in the process of picking the mediator, but you do not unilaterally pick the mediator. There is a good chance, Bambino Danon, that if you pick a popular mediator, defense counsel will just be fine with who you pick. If you pick somebody wild, I work as a mediator sometimes too, and I'll be upfront with you. There's certain plaintiffs who want to pick me, and defense counsel will be like, no, that guy's a plaintiff's attorney. First and foremost, that guy came up doing nothing but representing plaintiffs. You can't have him as your mediator. He's definitely going to side with you. And I would say to that, no, I wouldn't side with the plaintiff automatically. I would be fair, but I see why certain defense counsel are going to say no to me, right? So if you pick somebody who's viewed as fair, Bambino, they're probably just going to go ahead with your pick. They're not going to mind. They're going to want to make you comfortable. Pambaroon, why you keep deleting your questions? Why do I keep seeing message retracted from everybody here? Trey Moore says, is there a statute of limitations to obtain the decision from the arbitrator? Well, that depends on your jurisdiction and the terms of your arbitration agreement. Generally speaking, any arbitration that I participate in has an expectation that I will issue a fully featured and well-reasoned opinion within 2 weeks. But I can certainly see that being different under the terms of different arbitration agreements or in different jurisdictions. NYC Damages says, any tips on getting a judge to recuse themselves at the next hearing, since they won't do it before the hearing? For ex parte communications, I have evidence and a witness on the other side. Yeah, I mean, you could go to the disciplinary board for the judges if you really think the judge has done something inappropriate. Have you already raised this with a judge? Because sometimes raising with the judge can be sufficient. But if you already raised it and they don't think it has merit, there's a decent chance it may not have that much merit, but also that's not like, you don't have to figure that out. You can go to the disciplinary board for judges in your jurisdiction. And every jurisdiction is going to have that to some degree. Dintana Slim, hello to you as well. I hope you're well. Sean S says, thanks, Vince. Well, providing some info about the employer's attorneys, i.e. who has trail, ADR, and employment law experience, former judge, etc. JL firm is utilized by employer. Does that help? Not especially. I don't know a ton about the JL firm. Mario Ponce says, it's for severe depression. I outburst in the email, but there was no criminal threats. The employer, which is a state entity, is saying that they didn't know because they didn't provide the medical records. Yeah, I mean, listen. Oh, you go on. But my attorney claims that it's not my burden to give them medical records. The employer needed to ask for those documents. My burden was only to give them what my disability was. Okay, so listen, I'm not your medical professional. I don't know. And different depression is different in different people. I understand that. If you're asking me if I think it's an awesome argument, if I think most judges and juries are going to hear my depression made me have an outburst, I think you're going to have an education uphill battle. And you have to educate the judge, the jury, as to why and how depression can cause outbursts, because many people, such as myself, may be ignorant of that. I'm not super familiar with that. I know lots of things that can cause outbursts. I certainly know a million and one things that can cause outbursts, but I didn't know depression was one of them. I'm not saying it's not. Again, not a medical professional. I don't know. Just I think you're going to have to educate as to that, and you can make that argument. Big Skeens. Oh, by the way, everybody, it is 5:31. We've been going for 31 minutes. I am doing only 1 hour today. I'm doing only 1 hour. So we have 29 minutes to go. I apologize. I know usually I go for 2 hours. Today I'm only doing one. Trying to have a life. I hope you understand. Big Skeen S says, but I just don't feel like after everything gets way deeper than stated here, then just offering my job back is enough. The union is also partially paid by the company, so I feel they won't guide me to obtain the most I'm entitled to. The offer is reinstatement, seniority back, no retroactivity pay, and they want me to sign an NDA to go back to the same position and the same people. Yeah, so I mean, that's your choice, right? If you don't think it's a good deal, don't take it. But your options are take the deal, don't take the deal, or make a counteroffer. And it might be worth your time. So that's their current offer. You could make a counteroffer. You could say, hey, I appreciate the offer. If you add 50 grand to it, I would take it. I'm not telling you to add 50 grand because I don't know your situation. I don't know your damage calculation, anything like that. Just giving you a hypothetical, right? David Settle says, can you be hired to represent in another state? Yes, we handle cases in all 50 states, but only workplace discrimination and workplace sexual harassment cases. Is it good or bad thing to have co-counsel in a wrongful termination, discrimination, retaliation case? My case is in the appeal process. So just to be clear, you can't hire us on an appeal in another state. We take fresh cases that have not already lost some portion of the case. Like if you're on appeal, clearly you lost a decision somewhere along the way. So I apologize. That would not be a good case to hire us on. We have YouTube user Dissalina put in work, says lawyer filed with the EEOC, lawyer delayed response to the EEOC twice, and it was incomplete. EEOC did not find discrimination and gave the notice to sue. Lawyer dropped me and said I would most likely lose trial. I'm really sorry to hear that. That really sucks. Get a second opinion. Get 5 second opinions. Use our playlist of videos on how to find an employment attorney to get additional opinions. Don't just trust that that attorney does not sound amazing the way you describe them. Disguise 2023 Safety says, in light of your earlier comment, if the plaintiff sues the individual who discriminated within the defendant company, even if now a former employee, isn't that done under the tort law of intentional infliction of emotional distress? It can be in certain jurisdictions. Yes. I think there's additional laws that I would use on the federal side. But yeah, it can be. I mean, intentional infliction of emotional distress varies substantially in terms of its elements and its case law from jurisdiction to jurisdiction. So you're going to have to check with local counsel if that's a good option where you are. It's as the kids would say, a mid option here in New York. I'm actually not in New York, but if you're, I always pose cases as if they're in New York, because New York's very representative of many of the coastal states. So yeah, I mean, it's an option, and it's a good option in some jurisdictions. Annie Lynn says, happy Friday, everyone. Stay dry and have fun. Thank you so much, Annie. I hope you are well. It's always good to see you. Thank you for joining us today. Dantana Slim says, my attorney filed my claim in federal court a month ago, and my employer hasn't responded yet. Well, that makes sense. If they did waivers, they're probably going to have like 120 days or something to get a response in. So a 1 month response would be rather swift. If you serve them, then that's different. They would have to get something in. Cat Zap says, thanks, Vince. Of course, you are correct that the contract breaches and fraud were a hard sell. But at this point, my attorney is including them. I hope your channel keeps growing. Thank you so much. That's really kind of you. And I'm glad to hear that you have an attorney representing all the claims. That's amazing. So this Selena put in work is kind of going on telling me more about how their attorney failed them. One thing you might want to look at is if you paid that attorney money and they did really substandard work, you could look at the fee dispute options in your jurisdiction. I don't know where you are. You can also look at our fee dispute videos. They set out the process in New York, but they might inform you a little bit as to like how to go about checking things out locally. Or of course, you could always just talk to local counsel. NYC Dam just says disciplinary board for judges. Thank you, Vince. Would that be the same for hearing officers and city agencies? Bar attorneys serving as hearing officers or go to the bar in that case? So in my experience, judges have their own disciplinary board in most states. Often hearing officers or administrative law judges who work for state and city agencies will have an agency-wide process or group that keeps them honest. Bar attorneys, you can turn into the bar. Like if you think your attorney's doing something wrong, or even if they're doing something unethical when they're sitting as a hearing officer, you can still go to the bar association. That is still a viable process. If the bar association feels they can't help you because of their position, they can at least give you resources of where to go. So the bar association is always a tremendously good place to go. Remember, the bar associations in many ways exist to give non-attorneys recourse against attorneys, because it is perceived that attorneys have a power differential, right? Because we work in the system all the time, so we're comfortable with it, and it's easy for attorneys to get one over, as they say, on non-attorneys, which this might not be true in your case. You seem like a very clever person, but the bar association is there to help you to some extent. YouTube user Papa Smurf says, in an EEOC investigation, is the former employee always questioned? No. Typically, who does the investigator speak with first? So whoever they're most interested in, but often fact-finding conferences will have both sides present at the same time. Conversely, if they're doing things over the phone, I have often seen the plaintiff go first, the complainant in the EEOC. Quantum, I'm glad to hear you love the EEOC. I hope they help you out. Need to Watch says, YouTube user Need to Watch says, I received my letter from the EEOC to sue, and my lawyer did not want to file, saying, me and the other employer are not comparable, but we did the same job and worked in the same in every way. What should I do? Find another attorney. Use our Find an Attorney playlist. Use our Evaluate Attorneys playlist. Schedule 3 to 5 free consultations. Find better representation, and go ahead. Sean S. says, sorry, Vince, I don't want to name. I will not say the name of that firm. That was the firm I was referring to. That seems to be the employer's go-to defense firm. So that firm that you just named, well, I mean, it doesn't bother me. So I'm just going to say that generally speaking, when I see the firm Jackson Lewis, that is a budget defense firm. They're very good. They do a lot of repetitions. They do a lot of cases. They do more cases than almost anybody else, in my opinion. But they generally are going to be a firm that's indicating your employer has at least some interest in getting a settlement done. Don't get me wrong. They have great trial teams. They have great deposition attorneys, but they're not the most expensive, we'll say. They're a budget option. But frankly, the budget option here, Jackson Lewis, is better than some of the most expensive firms. I'm not deriding them by any stretch. There's not On the defense side, you'll find some of the most expensive white shoe firms just are incompetent. A lot of really big, like really high-end law firms spend a lot of time getting clients and a lot less time winning cases, and it shows. YouTube user, my other channel says, can the employer be forced to reveal contact information of other employees who can be called as witnesses, even if those persons are not employed at the company any longer? Yeah, you can get that in discovery. I don't see what, I mean, it sounds like you have a very good argument as to why you'd want to be in contact with those people. So I would certainly consider pursuing that in discovery. Cat Zap says, everybody, please hit the thumbs up button so we can grow Vince's reach. Well, thank you so much, Cat Zap. That's so kind. There's actually 36 of you watching concurrently right now, and I've got 15 likes, and that's pretty amazing. But a couple extra would help the channel grow. YouTube user Alien Superstar says, I submitted my rebuttal 3 months ago. Now the investigator wants to schedule a call. Is this for settlement talks? So it's probably a fact-finding conference. They probably have questions about the case, but they might also carry on some settlement discussions, certainly. Often when you have the investigator on the phone, they might bring up settlement, or you could bring up settlement. Or they might even just convey an offer from the employer. You never know. YouTube user Isaac's Trade says, what violations will an employer have to worry about when paying cash with no accurate pay stubs since 2018 to 2020? Since from 2018 to 2024, also paid no overtime when having employees work 60 hours a week. Oh, I mean, that's the Fair Labor Standards Act and a number of state laws. You're going to have a bunch of claims on the federal and local level there. Those claims are, they can be very sizable. And so I hope you get paid big. AR American says, hello, Vince. My lawsuit is currently in the discovery phase. What's usually the next step after discovery? How long does discovery typically last? So depositions are technically part of discovery, but I've noticed that pro se litigants view depositions as separate from discovery, often separating document discovery and your interrogatories from the deposition phase. So if you're doing that, then if you're in document and interrogatory discovery, the next stage is depositions. If you're grouping them together as an attorney would, the next stage is probably summary judgment or scheduling a trial. YouTube user Cuppy J says, my employer denied my accommodations and retaliated to try forcing me out. Do I need to make HR complaints for retaliation? Or requested accommodations can be viewed as a cause of retaliation? So you can paper those within the internal EEOC process and the internal EEO process, but I would probably recommend at the point where you're describing this that you would get something filed with an agency like the Equal Employment Opportunity Commission on the federal level. YouTube user Jason Thomas says, hey, Vince, saying hi to the channel. Didn't know you were going live today. Yeah, I actually just decided I was going live today, like 11 a.m. today. I'm only doing 1 hour. It's a quick one. You're not missing much. But I didn't know if I was going to have the gas in the tank today, frankly. It was a pretty big week with my clients. A good week. I'm certainly not complaining about the week, but it was a lot. I had to go to New York kind of suddenly, which I didn't love, but worked out great. So wonderful. Cassandra 8409 says, well, that escalated quickly. It always does when I'm involved. No, I'm just kidding. Isaac Trade says, party favors, praise hands, keep up the solid information. My pleasure, Isaac. I hope I'm helping. Okay, we've got 40 people concurrently. We have 21 likes on the channel. And I'm going to be frank with you. We have 17 minutes left. So if you got a question, you better be typing because we're not going to get everything. If people are making more questions last minute, I'm going to have to cut off at 6 p.m. Eastern time, which is in 17 minutes. So get your questions in. Excuse me. Dantana Slim says, a week before I filed in the federal court, my employer offered me a remote position, something I was asking for over a year in exchange for dropping my claim. I didn't take it because I don't. We're waiting. Excuse me. They're waiting for Dantana. Anish says, I bought Cremo. Thank you. So Cremo is my hair gunk. I hope you like it, buddy. Is it treating you well? Is it making you happy? I hope it's a little shiny, right? It's not bad. Cassandra is saying on a scale of 1 to 10, but I don't know what she's asking about. YouTube user Summer says, I'm in a position where I want to be vocal and use my experience as an advocate. I plan on publicly naming my employer, but I am in settlement discussions. I'm not excited to settle, but I am pretty tired after 2.5 years. Would waiting be the right move, or would bringing public attention potentially raise the pressure to settle and maybe a little higher? Okay, so here's how you have to think about doing publicity. It is a single shot tactic that can never be put back away, right? So we're not living in the newspaper realm anymore, where like you can shoot a story out in the papers and then it passes and the employer can wait and things are going to die down. Now it all lives on the internet forever. So if you do press, there's a good chance it can break down settlement discussions. Often employers are trying to purchase your silence in some jurisdictions, most jurisdictions still. There's a few like California where that's less viable. Excuse me, but it is, it's worth thinking about before you do the press to decide what you really want. If you're feeling tired, if you want to be done with this process, doing press might extend the process. So do be aware of that. YouTube user Anish says that the Cremo hair wax is a fire. I'm really glad to hear that. Many exclamation points. I'm so happy you're happy. Dantana Slim says, so we had a question from Dantana Slim, who did not take an offer of a remote position, and Dantana Slim goes on. I didn't take it because I don't like my employer anymore, and I was afraid they'd probably do it and fabricate an excuse to fire me. Was that a bad idea, or does it lower the value of my case? Well, listen, if they offer you the job, there's some arguments to be made that your damages are cut off because they try to get you back. Listen, that's not a perfect argument, certainly. Was it a bad idea? I mean, I don't know. It depends on your well-being. Like if you don't want to go back to that job, then refusing the offer is a great idea, right? If you did want to go back to that job, you just wanted more, then it might or it might not be a good idea. I don't know the specifics of your case. Anish, we can absolutely talk about settlement case management conferences. We've got 13 minutes left. If you give me a question, I will speak you an answer. NYC damages. Thank you so much for doing this. It's my pleasure. I know there were several people on here that you give confidence to stand up to or without an attorney on their side. Most attorneys are too expensive after you have been fired. Yeah, I get it. Listen, I mean, one of the big reasons why, shook my whole desk. One of the big reasons why I do the channel, or at least why I started doing the channel, was because we had gotten as a firm rather expensive and our clients became very affluent. Many of our clients are very, very affluent. And that's great because we make a lot more money that way. And I'm not going to lie to you. I like making money, but I also, I miss my old clients. I miss helping people. It's not that I'm not helping people now. We do. It's just that in many situations, we help people who can afford the best of the best. And that feels great. It does. But, I mean, my background's a little more trailer park than Park Avenue. And those folks need help too. And so, I try to do the channel originally, specifically as a way to give back. Oddly enough, the channel became an economic success out of nowhere, which was remains mystifying to me. So now it's this weird thing where like the thing that I did to give back accidentally ended up making me money. So that's weird. Like that's weird. YouTube user Kelsey says, what is the average length of discovery in a workplace discrimination lawsuit? 4 to 5 months. If everybody's being responsible, 4 to 5 months. You can have people stretch it out for a year, but it should be 4 to 5 months in federal court, in my experience. Cassandra 8409 says, this is probably the hardest thing to do. Hardest thing I've done in my life. So I assume you're talking about a workplace discrimination or workplace sexual harassment suit. I'm so sorry. I'm sorry. It's hard. It is hard. I can tell you that I know it's hard. I watch people do it, and it's incredibly hard as a non-attorney. And I'm sorry. AR American says, what's usually the time frame of the discovery process after the suit is actually filed? So it depends on whether or not you face a motion to dismiss. But you might, there's a good chance you will hit discovery starting in the first year. No guarantee though, right? An extended motion to dismiss phase could certainly push you outside of 1 year before you start discovery in a federal litigation. Trey Morris, more than happy to give advice. I hope it's useful. Louis Irizarry says, a federal company is requesting restrictions letter from the doctor when I submit everything true, all the proper channels, FMLA, and it's approved. They can request such documents. Yeah, they can ask what accommodations you need, what restrictions you have to work with. That's not an issue. My other channel, I know this sounds like a broken record, but thanks for putting your time aside to do these videos for folks. They are all good, especially those live feeds. You're the best. Happy. That's really sweet. Thank you, my other channel. I am aggressively mediocre, as you know, but yeah. YouTube user Corey says, a lawyer just getting started said, pay them $1,000 to take the case and only 25% if we win. I have a supervisor written statement saying I was being discriminated against. Is that a big win for me? Yeah, potentially. I mean, that sounds like a great case. And listen, if you're happy with that attorney, that sounds amazing. YouTube user Jason Thomas says, 9 minutes ago, everybody. Last questions are in. Last question is going to be Cat Zap. Cat Zap is the last question. Jason Thomas says, my coworkers teased me about having a handicap tag in my windshield. They asked me, why do all black folks abuse the system? Wow. Using handicap tags, and they're not actually handicapped. It kills me. Yeah, that is wildly racist, sir. That is wildly racist. I am really sorry that you experienced that. Papa Smurf says, thank you. Have a great and safe weekend, everyone. And you too, Papa Smurf. Okay, YouTube user Quetta Richard. Quetta, did I get your name correct? Please let me know if I got that correct. I want to make sure I'm saying it correctly. Quetta Richard says, after repeatedly telling my supervisor, don't ask about my children, he continues to do so. He then gave me a noogie, which is, I assume, this, rubbing somebody's scalp with your knuckles, in his office while I had a pending EEOC claim with these actions to be considered. Yeah, get those into your EEOC. Nobody has the right to grab you and physically touch you ever in the workplace. So I think you could argue that's retaliation. Antana Slim, yes, my cough is getting better. Thank you very much for noticing. And I had so much help from the channel. Really amazing help from the channel, getting the sound right. So I appreciate everyone so much. Cat Zap says, you remind me of Robert Barnes, a similar desire to help people learn the law, mainly constitutional, having come from a non-elitist background. Well, that's very kind of you to say. I don't know if I deserve that praise, but I'm going to feel good about it anyways. So thank you. Jason Thomas says, the tag for my father-in-law, his throat cancer came back and he had to have his entire neck reconstructed. It was none of their business. Is it considered disability harassment? It might be perceived disability harassment. I mean, I would say it sounds more like a racial claim to me, but it could certainly be perceived disability harassment. Really sorry about your father-in-law. I myself had throat cancer, and you can probably tell I'm missing like a third of my neck here. I hope he's all right. YouTube user Chris says, I was laid off from work and my company hired students at less money, but did not give me any money or a package. I didn't sign off and told me I would not be returning. I worked for them for 8 years. Man, Chris, I'm really sorry to hear that. That's terrible. Have a good evening, Sean. Have a good evening, Cassandra. I hope all is well. Have a good evening, Isaac's Trade. Quada, thank you so much. Thank you for teaching me how to say that. I'm really sorry. I will do better in the future. Thank you. All right. We have 6 minutes left. I thought we were going to take longer to answer those questions. I am getting faster with age. Do we have more questions? Okay, we might not. Everyone have a wonderful weekend. Oh, last question. Drama fan. Oh, wait. Is it worth requesting company review of a retaliatory performance improvement plan, or should you just complain to an outside agency? I would complain outside. Internal review is for is for them to paper your file, right? Anything they're in control of is not in your favor, in my experience. Just be aware of that. All right, everyone, I'm gonna give myself 100 likes, and thank you so much. We had a great crowd tonight. I think we hit 40 concurrents, 25 likes. I'm gonna try to do these more often. Have a good day, Chris. Happy to help, and I hope you're all having a great weekend. I gotta work on processing some chickens, some meat birds, so I can have tasty chicken dinners. Take care.